Hello, my name is Sam Brooks. I am an attorney in the Aging and Disabilities Unit at Community Legal Services of Philadelphia. Community Legal Services, otherwise known as CLS, provides free legal help to low-income Philadelphians. I and the other attorneys in my unit work with disabled and older Philadelphians around a variety of legal issues, including long-term care, Medicare and Medicaid rights, and Social Security benefits. At CLS, we are frequently contacted by individuals who have questions about the Pennsylvania Department of Public Welfare's Estate Recovery Program. The most common question we receive is, am I going to lose my home, or do I have to sign my house over to the state if I want to receive long-term care services? We always answer no. Nobody ever has to sign over or give away their home to the state while they are living just to receive long-term care services. Because there are so many myths and misinformation regarding estate recovery, I will give a brief overview of just what the estate recovery program is and try to dispel any myths that you may have heard. So just what is estate recovery? Estate recovery is a program administered by the Pennsylvania Department of Public Welfare, also known as DPW. The federal government requires states who provide Medicaid-funded long-term care services for individuals who are 55 or older to try and get the money they paid for that long-term care back after the individual passes away. Long-term care includes stays in nursing homes and also home and community-based services, or waiver program. It is most common for CLS to hear from people who have applied for waiver services or are thinking of applying for the waiver program and have questions about estate recovery. The waiver program is a Medicaid program that pays for in-home care for individuals who would otherwise need to leave home and live in a nursing home. First off, estate recovery is something that occurs after the recipient of long-term care services passes away. Nobody ever has to sign over their home to the state or place a lien on their property while they are living in order to receive long-term care services. This is a common myth and one that prevents a lot of eligible individuals from receiving long-term care. Let me tell you how the program works. After a person who has received Medicaid-funded long-term care services passes away, DPW's Estate Recovery Program will contact the family members of the individual. DPW will request that information regarding the individual's probate estate be provided to them on an inventory form. A probate estate is what the recently deceased person owned when she passed away, which would normally be distributed to her heirs. Remember, Medicaid is a program for individuals with limited income. Because of this, generally the only asset left in an individual's probate estate is their home. DPW is not concerned with a person's personal belongings, but wants to know about any possible cash resources and, most importantly, the home. DPW wants information on your home to see if it can potentially recover the cost of care it paid for. This is what scares both applicants of long-term care services and their families. Why get services if it is going to result in the loss of your home, sometimes a home that has been in your family for decades? Frequently, we are contacted by individuals who have or are planning to change the ownership of their home to avoid estate recovery. We always caution people not to do this until they have spoken to a lawyer. I will explain why later. We at CLS urge callers not to reject services out of fear of estate recovery. People should always receive the care they need. Just because DPW may have a claim against an estate does not necessarily mean it can or will take the home. There are many exceptions, and it also depends on how the deed to the home is written. I will briefly discuss these exceptions now. Knowing how your home is owned is very important. Do you own it outright? Do you own it together with your spouse? Whose name is on the deed? Just because you live in a home does not mean you own it. For instance, your spouse or a relative's name could be the only name on the deed. This means you do not own the home, and DPW can make no claim against it. Again, if your name is not on the deed to your home you live in, it is not subject to estate recovery. For individuals who own a home with their spouse, it is very likely that upon their death, their home will pass to their spouse, free and clear of any claims by DPW. Estate recovery regulations prevent DPW from seeking recovery from a home if the deed has language saying that it was owned with another person as tenants by the entireties or as a joint tenancy with a right of survivorship. This is legal language that will occur on your deed. If this language occurs in your deed, then when you pass away, and if the other owner is still alive, your interest in the home will transfer to the surviving owner. The other owner may be your spouse or may be another person, such as your child or sibling. If this language is on your deed, and the other owner survives you, it means that the home will not be part of your probate estate, and DPW can't make an estate recovery claim against it. If you're unsure if this language is on your deed, you should contact us, and we'd be happy to look at your deed with you and advise you. Also, if there is different language on your deed, you can contact us, and we can explain what it means and whether the state will be able to state a claim against your home. But what if your name is on the deed and you don't own it with another person as joint tenants by their entireties or with a right of survivorship? If you pass away and you have a child who is under 21 and living in the home, DPW will postpone recovery until your child reaches 21. Also, if you have an adult child who lives in the home and who is blind or disabled, DPW will postpone its recovery until the death of that child. DPW also provides for hardship exceptions. DPW will waive estate recovery in instances where a person lives in the home and provided care and support to you. Waiving recovery means that DPW will not pursue any claim against your home after you have passed away. For instance, oftentimes a family member or another person will be living in your home when you pass away. If that person can demonstrate she lived in the home with you and provided care and support to you for at least 2 years during the period of time you were receiving waiver services, DPW will permanently waive any recovery from your estate. DPW will also waive recovery if the person living in your home when you passed away provided care and support to you for 2 years prior to you entering a nursing home. In both cases, the person living in your home will have to document that she owns no other homes. Let me give an example. John Smith recently passed away. He received waiver services for 4 years. The only thing in his probate estate is his home. However, his niece Brenda Smith currently lives in his home. Brenda has lived there for 5 years, including the period of time when John Smith received waiver services. If Brenda can show that she lived there and provided care and support to her uncle during that time, and she also has no other place to live, she owns no other home, DPW will waive estate recovery. DPW will want her to get a letter from her uncle's doctor saying that she helped take care of him at home. We are happy to explain how this works in more detail. There are other less common hardship exceptions. For example, if the home in question generates income for your spouse, child, parent, sibling, or grandchild, DPW may waive estate recovery. You should contact us with any questions and to learn more about hardship exceptions. It is very, very important that you take no action to transfer any interest you may have in your home before talking with an attorney. Taking your name off the deed of your home or adding another person to the deed is likely to affect your eligibility for Medicaid-funded long-term care services. You should not transfer any interest in any property before speaking with an attorney. If you do transfer your interest in your home without getting paid fair market value for it, DPW will penalize you for this transfer by making you ineligible for services for a significant period of time. There are some transfers that are allowed. For instance, if you transfer your interest in a home to your spouse your child who is under the age of 21, or your child who is an adult but disabled, you will not be penalized. But, and this is a big but, you should always speak with an attorney before making any changes to your deed or taking any action regarding the ownership of your home. We are happy to advise you privately and confidentially. To recap, 1. Nobody applying for or receiving long-term care services paid for by the Pennsylvania Medicaid program ever has to sign their home over to the Pennsylvania Department of Public Welfare while they are alive. No lien will be placed on your property. Estate recovery potentially occurs only after you pass away. 2. The language on your deed about how you own your home will affect what claim DPW may have against your home when you pass away. 3. Never transfer your interest in a property before talking to an attorney. You do not want to jeopardize your eligibility for services. 4. There are exceptions to estate recovery. We have gone over some of them today, but you should contact us if you have more questions. 5. We hope that you will not turn down needed services because you fear about estate recovery. You should always get the care you need. We hope that this video has been of assistance to you. There are many myths and misinformation about estate recovery, and we want to help people understand how it really works. If you have additional questions, you can contact us at Community Legal Services. Thank you.